Welcome back to Digits here at WSJ Live. I'm Simon Constable. Well, here's the question that Apple Samsung jurors are going to be reading. For each of the following products, has Apple proven that it's more likely than not that Samsung infringed the indicated Apple utility patents? Answer each cell with a Y for yes and an N for no. I got this thing here. It's quite incredible. It's like a quiz. It's like you're back doing some sort of GMAT, SAT, something like that. Anyway, we've got Jessica Vascellaro in San Jose joining us now on the phone to tell us all about this. Jessica, these forms are incredible. They're giving me flashbacks to high school.
I know. They made me want to sharpen my number 2 pencils for sure. But yeah, what you were actually reading there is one of the proposed, is actually an earlier version of the form. Actually, I can already note that some of that wording has changed slightly because the two sides here are still fighting over exactly what this worksheet will look like, because, you know, it's just what this whole thing will boil down to and what the jurors will decide. And hopefully we'll have an answer on the final compromise later today. Now,
I mean, just to quickly go through this form, I mean, there's so many different things. I mean, they've got the Intercept, the Vibrant, the Captivate, the Epic, the Fascinate, the Gal. I mean, it just goes on and on and on. I mean, there was some talk by the judge last week saying, look, you don't want this to go to a jury. Why don't you just get on the phone with each other? Maybe not a Galaxy phone or an iPhone, maybe something else, and talk about it, because it's going to be not much fun for the jury and not much fun for you either. Is there any chance of that happening?
Well, I think, you know, both sides said that the CEOs were going to talk before tomorrow when this could go to the jury, or Wednesday, and we believe that that's still the case. But, you know, everyone's getting there. These companies have tried multiple times to reach an agreement, and, you know, this is, I think, really just a token move. But, you know, we'll see. But the forms, you know, what you were listing, those device names, I mean, these jurors, 9 jurors, are going to go device by device, patent by patent, determine whether they think the device infringed the patent, whether they think the patent is valid. They're going to do the same for the patents that Apple's asserting against Samsung and the ones Samsung's asserting against Apple. And then, you know, there are going to be some damages numbers that they're going to determine. They're actually going to, you know, fill in some of those boxes with a number of what they think, you know, whoever is found infringing owes the other. So there really is a lot to work through.
There's a heck of a lot to work through. Now, this isn't a criminal trial, so the standard of proof is somewhat lower. It's the preponderance of evidence, right?
Yes, so they actually, I think the latest update is they're going to actually agree on this preponderance of evidence term versus the more likely than not term. So we can parse what Apple may have been wanting by more likely than not, but it seems like they've switched to preponderance of evidence. But the jurors do have to be unanimous to find infringement. So that's another thing that, you know, that is still a high bar to find infringement, but you know, one other thing that's going to happen today or tomorrow, which is very critical, is the reading of the jury instructions. So you've got out there the form that they're going to fill out. They're also going to listen to the judge read for about an hour and a half, she estimates, a long list of instructions about how they're supposed to apply the law. So this will explain to them what a design patent is, what trade dress is. It will tell them things like, try to weigh the testimony of experts equally, even if they testified in person or not in person. So that's another thing jurors have to absorb before they actually get in the deliberation room and try to reach a decision.
So Jessica, to take us through this, so for each question, they have to determine whether each item that's listed, and there are tons of them, was infringed on the patent, yes or no. And for each one, there has to be a unanimous result. And then if there is, then they have to determine the damages. And then, am I right in thinking that then there's an appeal process?
Oh, for sure. I mean, I think everyone's expecting whatever outcome to be appealed for sure. In fact, I saw a post this morning, some documents. They're already quibbling over the procedures for what happens after the verdict comes out and objections and all and all of that kind of stuff. It's widely expected that that will happen, but also this is the first case between Apple and Samsung in the patent arena, smartphones, to go to a verdict, and actually there was one that went to trial, but it's at a different pace. So whatever happens will go far to sort of affect a lot of other things going on. So even though you can expect it to be tied up forever, it's gonna have a big impact.
Well, I bet the jury are hoping for time off for good behavior or something like that. We'll have to leave it there. Jessica Vascellaro of the Wall Street Journal in San Jose, covering the trial there, and more on that Samsung versus Apple on WSJ.com.